On Friday, we had dealt with 14.2. I'm not sure if there are any more outstanding matters on 14.2. That was the role of the shareholder. Let's not argue about the headings now, but the focus areas. And that leaves us with 6 recommendations, albeit some of them might have sub-sections to them. From where I'm sitting, honorable members, can we aim to conclude those 6 recommendations today? And the reasons are so that Cindy would be able to go back and put together the most updated version. Send that updated version to us. And then on Wednesday, we deal with those few there where there might be, for want of a better word, variances. Deal with that and conclude that on Wednesday. Then we give Cindy and her team the whole day on Thursday to then put together the final document. And then we will need a very short time on Friday to adopt the final document. So that's what I'm envisaging, that we deal with everything today. Cindy will have to run away and at some point tonight give us a document that in certain sections might have 2 or 3 versions as it was deliberated on. We then try and tie up those diversions or variances on Wednesday. On Thursday, Cindy and her team will then go and put together that document, send it to us with reasonable time so that on Friday, we then look at that document, adopt it as our draft report, and then decide on the way forward. So in terms of what happens after we've adopted it, we'll discuss exactly who do we send it to, how do we make sure it gets to those people. Is that program in principle agreed to? Okay, then. If that is the case, honorable members, can we then move on to, I think it's page 33 on my document. I'm not sure other members have the same document, but it should be page 33 that talks to legislation. I think in the main. That's what I'm saying, that one there. Yeah, I'm saying in the main it talks to the legislation governing it. That's what I'm saying, yeah. If we're all there, can we get an indication if there are any comments on 14.3.1? Honorable Swartz, and then let us just be organized. I apologize for that. Honorable Swartz will be followed by Honorable Khoza, and after Khoza it will be Kubisa, and after Kubisa it will be Killian. On 14.3.1, Honorable Swartz.
Chair, in this regard, one needs to refer to the legal opinion that I was going to present at some stage, and that was drafted by the legal advisors, that makes it very clear that the Broadcasting Act trumps the Companies Act. So that is already been provided electronically. So it will form part of the report. So one can, I don't know, one can decide, it can come in here or wherever, but in terms of that opinion, there's no uncertainty. So whether one then needs to say, to the extent that I don't think it's necessary, but it might be when we discuss recommendations for those that might think there is any uncertainty. But our view should be that there's no uncertainty. And so And that would be buttressed by this 3-page opinion that makes it very clear, Chair, how the two acts liaise with one another, and that when it comes to the removal and appointment of board members, it is very clear that the Broadcasting Act applies in terms of various maxims. Thank you.
No, as we've been saying all along, Honourable Swartz, we hear what you're saying in terms of backing it up, but that recommendation 431, what are you saying? 1431, what are you saying? We must find because remember, are you saying we must find a wording that makes it very clear that the Broadcasting Act?
Correct, Chair.
If that's what you're saying, we will do that, and
Correct.
we can look at it on Thursday.
I would just say I'd refer to the legal opinion and say it is this committee's view that and that's the end of the story.
All right. Thank you very much, sir. So there's Honourable Singh. Honourable Khoza? I beg your pardon, not Singh Swartz. I beg your pardon.
Sorry, Chair. I'm partially covered. I wanted us to be assertive. The committee has a position, and I think that position must not be ambiguous. Thank you, Chair.
Please, sir.
Of course, Chair, it would be crafted in a way that says the Public Broadcasting Act supersedes any other act.
Baba. Killian? Thank you very much. So that deals with 1431. If that is the case, 1432 shouldn't be an issue. We can tick 1432. Yes? Okay. 1433? I'm sorry. Let's start. No, hold on. All right, we'll get there. Or maybe we'll try and do that, but just note names. Killian and then Swartz. Let's start by trying to tell you what we meant, because remember, and I beg your pardon, and Mukwena. Well, remember, well, everybody wants to speak. Mukwena and then Mahlangu. Van Dam, and then Chauke. What we were trying to say, honourable members, remember we're talking about regulation. We've now agreed which regulation we think supersedes. All we were trying to say there is that that regulation must make sure that there's no encroachment. That's what we were trying to say there. Now, if it's necessary or no longer necessary on the basis of our deliberations, you can either say it doesn't matter anymore, or you can strengthen it, or you can weaken it. But what we were basically trying to say there was that whatever the regulation is, the principal regulation, and remember 14.2 then says all the subsequent regulations or whatever must be aligned to the principal one. After all that is said and done, the intention is that there must be no encroachment by the shareholder, and no encroachment. In other words, there must be a clarification of roles, whether it's the shareholder, whether it's the board vis-a-vis the executive or the administration and so on. That's what we were highlighting there. Now, is it still necessary if we fix up what Swartz is saying, yes or no? If it is, how do we strengthen it? So that was the intention of 1433. So let's then start with Killian. It will follow by Swartz, followed by Mukwena, Mahlangu, Van Dam, and Chauke. Killian.
Chairperson, yes, this is perhaps better. I want to move that we retain it, but that we just perhaps clarify it. That we say there must be a clear understanding of the respective roles of the shareholder, the board, and management of the SABC. And then obviously with shareholder, we mean shareholder, also Parliament and the executive. But be that as it may, I wanted to suggest that we also include at all times, must at all times be regulated in line with King III principles, so as to ensure that there is no undue encroachment in matters normally reserved for the SABC board and management. Because in some respects, what we have seen was there was also involvement in management administrative matters. And we must also list, on the one side, board intervention in board activities, and on the other side, management. So I just thought, let us just put in the belts and braces. I know you said we shouldn't try to do too much, but I think there must be very clear understanding of what we mean. Thank you, Chair.
Honourable Swartz.
Chair, here now, when we refer to principal legislation, one is referring to the Broadcasting Act. However, one knows as well that when it comes to Memorandum of Incorporation, that's in terms of the Companies Act. So we need to ensure, and I'm in agreement in the previous, the King III is very good, but we need to align to the Broadcasting Act as well as the Companies Act, where applicable. Because you'll remember the Memorandum of Incorporation is in terms of the Companies Act. So both apply when it comes to governance of bodies. When it comes to the appointment and other issues, we've focused on the Broadcasting Act. So I think here, if you can help me, the principal legislation is the Broadcasting Act. And so we need to focus on that, and then to say, as well as the Companies Act and any other applicable legislation where applicable, together with the King Code. Thank you, Chair.
Honourable Mokoena.
No, Chair, I say this in danger of repeating what has been said before, but I thought it would be more prudent for us to start with the principal matter that the Broadcasting Act must remain as is. So we start with that at the beginning. So for 14.3.1 is that the principal guiding legislation is the Broadcasting Act and must remain as is and unchanged, as we know that there's a process of time to change the thing. Because if we do that, then the roles of the shareholder and so on and so forth would have been clarified in that Broadcasting Act, and then we don't have to put that in. It's my humble suggestion. Thanks, Chair.
Honourable Mahlangu. Thanks, Sibab. Mahlangu.
Chair, I think, my colleagues have covered the matter quite well, that the appropriate legislation should apply. In this case, I recommend that we don't say King III, but let's say just the King Code, because now you have King IV that was released 1.5 weeks ago. King Code, then we'll have the latest code that is applicable. But I think the laws that have been referred to, which is the Broadcasting, the Companies Act, and the King Codes then kicks in. I think the sentiment is fine, Chair. I think I'm fine with it. I'll leave with what has been said already.
Honourable Van Dam.
Thanks, Chair. I think I'm partly covered by a little bit of what everyone said. So my input speaks to both the previous clause and the current one. So the Broadcasting Act isn't explicit about the role of the shareholder. I mean, it's a principle that there shouldn't be involvement. And it's normally something that's clarified in the Memorandum of Incorporation, which clarifies the rules of engagement with the board and the executive. So can we add then for 14.32 to also cover that, to say that the MOI must be amended in order to also clarify the role of the shareholder vis-a-vis the board and the SABC's management?
That's fine. I don't think it's a problem, because what we are saying is, if you know better than us, maybe because you served there, if you're saying the principal one is not that explicit, wherever they find it appropriate, the portfolio committee, we think that must be what's happening. No problem with that. Honourable Chauke?
Yeah, I think I'm very much covered.
Thanks. Honourable Waters?
Chair, I'm covered on everything. Just on the point that was made about suggesting the Broadcasting Act doesn't ever get amended again. I don't think I understand where the sentiment's coming from with this particular amendment, But you can't say that in any report, because, I mean, in 2 years' time, we might want to change it for whatever reason. Okay, well then... Okay, well, maybe I misunderstood, but okay, but...
Those amendments that they've suggested should not
Okay, all right, okay, then I'll withdraw, Chair.
No. Yeah, we'll find, remember, we'll debate it. I think what everybody is saying is what we've discussed earlier on in terms of trying to fix it up in terms of the Principal Act must remain as is, and any other legislation that attempts to deal with that one for now must be something that people must be circumspect of. And it wouldn't be us, it would be the Portfolio Committee, of course, and anybody else. I think that was the sentiment. So I think we're all on the same page there, honorable members. All right, I suppose we must do the same with 1443. What we were saying there, and again, honorable members will decide whether it's necessary, whether it's in the right place. You'll recall that the public broadcaster is public and also commercial, and they receive majority of their revenue through advertising, sales of advertising, and a limited amount through directly from the fiscus. That's what we heard. And what we were trying to say there is whatever happens, it's no use cleaning up and fixing up the administration and the board, but if there is no sustainable funding, then we'll also defeat it. That's what we were trying to say. Now, is it relevant? Is it not relevant? Is what you guys need to talk to now that you understand the sentiment, or even if it's in the right place. So we'll try every time we get to one, we'll clarify what our thinking was and you'll decide. Let's start with Loliwe and go to Waters. I'll try and give everybody bites that haven't spoken. Chauke, we'll come to you, Makosi, and then Kubisa, and Swartz. Loliwe?
Thanks, Chair. Chair, I agree with the sentiments shared there, but I think we need to insert something which talks to the emphasis on its public mandate, because much as it is both for public and commercial, but its mandate is more on serving the public.
You don't have a proposal for us there, ma'am? Remember our principle last week? You make a suggestion, you sponsor the answer.
All right.
Because otherwise you leave it to us.
Can we, after sustainability, include with particular emphasis to the funding of the SABC public mandate?
Okay, there's one. And then let's take Waters.
Chair, I agree we should have this paragraph in the report. I just want to suggest that we should, it's just out there in the ether. I think we've got to say that the Portfolio Committee and Communications must look at the funding model. I think we must stipulate that so we know who's responsible. So I would like to suggest that. You can put that anywhere in the paragraph. It's fine.
Thank you, sir. Chauke?
Chair, maybe we have to deal with the principle with regard to the funding of SABC, that I think no matter how much it is funded by public pairs, it must be understood that SABC, it is public funded. The rest, what they raise outside is something else. Because if you remember the argument of the Maguve then, was that, in fact, we don't derive our funding from yourselves. We raise our money outside there. It's after, but it is a public funded institution, meaning that the body is public funded. Even if it was funded with R1 share, the fact is that it is funded, there is an allocation that goes to SABC from the budget that we pass in Parliament. So therefore, it is public funded by what's called. So I thought that we use that principle. Moving forward, the rest of what they raise moving forward becomes something else. We deal with the principle because the issue has been around accountability. Remember that because you don't give us money. Therefore, I remember when I was in the Sports Portfolio Committee, the rugby union will say, we don't get money from Parliament, therefore we are not accountable. So I think let us emphasize that point, that it is a public institution, it is funded within the the fiscals. So I think it must be that principle that sort of oversee, or whatever that they'll go and raise anywhere, but the principle still remains that it is public funded.
Thank you, Chair. First of all, Chair, I think it's important that we acknowledge the fact that SABC can be self-sustaining whilst fulfilling its public mandate, public broadcasting mandate. Chair, I wanted to sponsor the way we should be phrasing that paragraph. I agree with it, but I thought that maybe if we say a detailed analysis of the funding model of the SABC must be conducted to ensure that the public broadcaster fulfills its mandate whilst retaining its competitiveness as a commercial entity. Full stop. This should be done as part of efforts to ensure its long-term financial sustainability.
If you can also pass that on to us, because we might not have captured it all, but we've tried to capture it. If you could pass that on to us in writing, that's fine. And Honorable Kubisa?
Chair, I wanted just to say the PC Committee on Communications should ensure that the funding model of SABC is well regulated. That was my contribution, Chair.
Honorable Swartz?
Chair, this issue goes to the heart of our mandate, which is to look into the financial status and sustainability of the SABC. Now, I provided that document myself and Dr. Kaza on this issue, which relates to the performance management report of the AG. You did express reservations about that, about to what degree we should use that information, but it does raise severe concerns about the funding model and whether the SABC is an ongoing operation. So, Chair, I'm not sure that extract will be contained, and then we can decide to what degree we need to. And it might be wise to refer to the AG and say, look, this is information. We're not supposed to disclose it in terms of the Public Accounts Audit Act, but it is before us as Parliament. That does raise severe concerns as to whether it is now an ongoing concern. So there are two issues here, the funding going forward and the present situation. So I'm totally in agreement about looking at the funding model going forward. But somewhere we need to also say, but what is the situation now? And the Interim Board needs to urgently look at that, because that is the financial status and sustainability, that is our mandate. So we need to also recommend, and I've got the wording in that draft report, which we can consider, that the committee, from the information at our disposal, expresses its concerns about the financial status and sustainability of the SABC, and it requests the Interim Board to urgently investigate this issue and report to the Portfolio Committee on the financial status and sustainability of the SABC. And then we can add, and the funding model going forward. I don't know if that, because that is an issue of concern. But I do want your guidance as to what degree should we approach the AG and say we are going to use information from the performance management audit and refer to that. I don't want to, they might come back and say, well, in the meantime, that whole thing has changed anew. But if I can just emphasize that point, that financial statement and report given by the AG was at 31st of March last year. In the performance management report, they refer to a substantial deterioration subsequent to that, and they give an indication of that. By now, it could have even reached worse situations. And SOS, I think, in their written submission, refer as well to a looming financial crisis. So I hope that helps slightly, Chair. Thank you.
Yeah, no. I've noted Kwankwa, Loliwe, and Killian. I'm just thinking aloud. I think, because we don't want to be writing theses in our recommendations, so I think you need to marry these two, the current situation and the going forward situation. So you guys will find a way of marrying the two without tramping on the AG's toes or anybody else's toes. But let's not have a recommendation that's a whole page. I thought our recommendation should be sharp and and short so that they are achievable and understandable. Kwankwa, followed by Loliwe, and then followed by Killian. We're dealing with 14.3.4.
Chair, I think you've covered me in your input by saying that we can combine the two proposals, because indeed I think that recommendation there, the review of the funding model deals. It's not even here. Okay, that one is off. Sorry. Sorry for that. And I think really it's about the. No, I think the sabotage one with Dr. Koza. Chairperson, it's all about the revenue mix between public and private funding, really, that we're trying to deal with here. And I think the problem is with this money.
Go to the tape.
Wait. Ayikona lapha mfutshane futhi.
Cima into zakho.
I'm a minority party. Next time. Well, Chairperson, I think really deals with the, it's more like we're saying, we're looking at this thing, it's looking at it on a more forward basis. We're saying, in future, how do we address this problem? When you're looking at the balance between your private funding and your public funding, right, to ensure the financial sustainability of the SABC. So I was saying, indeed, I think we should combine the 2 points. But I think what is important, maybe it won't be captured in the recommendation itself. We should not really be worried about what, the misunderstanding of the SABC board and how they generate revenue. Remember, if I give you my house and you use it to generate revenue, it still remains my house, whatever model you use. It's a public asset that they're using to generate revenue. Whether they generate most of their revenue using the commercial arm of SAB is neither here nor there. So they're still accountable to us, the people of South Africa, in terms of how they use the money. So I think it's more striking the balance between public funding and private funding and trying to establish whether that is adequate for the financial sustainability of the SABC. Thank you.
Honourable Olive.
That was the SABC Ad Hoc Committee, currently busy there. We'll bring you an update of the deliberations there in Parliament.
Right thesis. Because that part which talks to what is currently happening, as suggested by Honourable Swart, to me, is something we might have missed when we were noting our observations. It's not supposed necessarily to come to the part of the recommendations. And also, lastly, the portfolio committee where I'm seated is in existence. So let us not burden our recommendations with the work that is to be done by the portfolio committee, because we can't dictate to them. Thanks for the noise, Honourable Chauke and Van Damme.
Thank you, Chairperson. Chairperson, can I just say that I would just like to convince Honourable Kwankwa and Honourable Swart if we can't perhaps make a very short recommendation under the heading accountability. Because remember, it's part of the SABC's responsibility to report to the Auditor General, and any shortcomings in their annual reports, etc., actually should reflect under the accountability part. So perhaps it would not be a bad idea. I know Honourable Swart sponsored a section that should probably, well, I think he submitted a 2-page document that should probably be slightly shortened for the observations part, Chairperson. And then obviously the recommendation could flow from there, that noting the concerns expressed by the Auditor General in its audit report as well as the management report. We request the portfolio committee, because ultimately we have to hand back the baton to the portfolio committee, should call the SABC board to reflect on its financial sustainability at present. Something like that, Chairperson. Then we cover the issue without going into too much detail. So I was just wondering if there would be any appetite for such a suggestion. Thank you.
I'm going to repeat this thing. Nobody's wondering, nobody's asking questions. Put your proposal on the table and it will be deliberated upon. Because we'll also wonder here from the table here. We'll also just wonder and not put it in. Because you're not suggesting anything. All right?
Chairperson, that's a firm
covered.
proposal.
No, I'm saying that in jest. I'm saying that in jest. The last one on that one, again, our thinking was, honourable members, remember we had the big fight about whether the archives are sold or not sold and all that jargon. As late as this morning, I was reading some legal advice, I think it was between ICASA or somebody that was really saying, at the end of the day, I think they were saying they might not be in trouble when it comes to establishing, they might not be in trouble when it comes to maintaining, they might be in trouble when it comes to giving it or making us see it. I think that was the recommendation. That's what we were trying to do. Now, we don't have to have a debate about it because, I mean, we're not the experts. I think what we were trying to say here is that take all those things into consideration and just, whether it's regulation, whether it's just oversight or whatever the case might be, ensure that South Africans at all times will be able to access what is ours. That was the intention here. So members will then decide whether it belongs here, do we shorten it, do we make it more specific, and so on. I see Honorable Mukwena. That's 1435, eh? Yeah, Mukwena, Kubisa, and Waters. Mukwena.
Thanks, Chair. No, the actual status of the archives is that they belong to the National Film and Video Library. Now, the National Film and Video Library falls under the Department of Arts and Culture. So, in essence, those archives do not belong to the SABC. And there was a plan by the National Film and Video Archives to rehouse them somewhere else. But they didn't have space and so on and so forth, so they left it at the SABC. So I think the recommendation, seeing that those archives belong, they fall under the stewardship of the arts and culture. The recommendation should be that arts and culture must conduct an investigation into the status of the archives, take steps where necessary, and map out a way in future to secure them against such, whatever.
Honorable Kubisa?
Just like you, Chairperson, I was reading the comments from ICASA with regard to the archives and the material that was sold to MultiChoice and how far the matter has gone to court. So it seems there's a lot that is involved there. So with regard to this one, I wanted to go back to the fact that I do hear what Honorable Mgwana is saying, that this belongs to the arts and culture. But I was of the view that all that we have with the SABC needs to be within the legislation. That in the envisaged, in the bill that is coming, it must be well legislated that we, the public, are the custodians of those funds. And the SABC must ensure that these funds are well kept within the ambit of the legislation. So that we have these arms kept by the SABC, but on behalf of the people. That was my take, Chairperson.
Honourable Waters?
Chair, as you rightfully said, that legal opinion we got this morning from Motsaneng and Bill attorneys clearly states that they have three obligations which they met to. They've established an archive and a library, they've maintained it, but as far as access is concerned, they haven't done that. It's been restricted to Mnet or MultiChoice. And so if you take that into consideration, they've breached they've breached the policy. Now, if you look at 13.35, it says we should need to consider 14.35. Sorry, the clause we're dealing with. Aren't we on 14? We're on 14, I hope. Else I'm really out of it. Okay. All right. Thank you. Okay. It says we need to consider a policy with regard to the management and custodianship of the archives and libraries, but we have a policy. So, and the fact that these attorneys, I know it is a legal opinion. It may, you may get a different legal opinion, but the fact is, according to them, SABC has breached the policy. So we have a policy. I think if we need to tighten it up, what we should do again is suggest that the PC on communications deals with it and comes up with a tightening up of the policy so that where it needs to happen. Just on the point of arts and culture taking over the responsibility of the archives, I haven't actually thought of that, but the Broadcasting Act, if I understand it correctly, I need guidance here, is the custodian or falls under the Department of Communications. That would then say, and it's specifically there for the SABC, so that for me it means the SABC is the custodian of the archives, but doesn't mean it always has to be, I suppose. It could be a recommendation from the PC committee saying, arts and culture should take it over, whatever the case may be. I don't think we should preclude any suggestions. But that's my suggestion, Lecture.
I agree that we need to mention it, so it should be there. I would, however, suggest that we make specific reference to the relevant section, because this section is 8J, and as you have correctly referred us to that in the past, it is to establish and maintain libraries and archives containing materials relevant to the objects of the corporation, which is correct what Honourable Waters has said, and to make available to the public such libraries and archives with or without charge. Now, clearly we can't go into the details of it, whether this complies or doesn't comply. So I would suggest, similar to what other members are saying, is that we need to say the Executive and Parliament needs to review the policy or reconsider the policy with regard to the management and custodianship of the SABC archives and libraries, which should be in line with Section 8J of the Broadcasting Act. In doing so, Chair, we actually, we don't dictate to them, but we say check whether the policy is in line and then make sure that it is applied. But Honourable Waters said we should give the responsibility to Portfolio Committee of Communication, and I would like to support that. Absolutely. Thank you, Chair.
After everybody said everything here, which is fine, can't we just say that Section 8J must be implemented in full? Because it's covered in Section 8J, isn't it? Except for the portion that you're raising. Because nobody is disputing 8J as it is, and all we need to say is that if we want to add the part of possibility of joint custodianship or alternate custodianship, then we can add that. But 8J seems to be what we're all saying, as it stands currently. Correct? All right, thank you.
I'm not sure that we have not looked at the regulations of yours that implement 8J. Maybe to emphasize the point that including the regulations must be in line, so that we are able to balance the gap. You see, 8J deals within the Act itself, but then the implementation of 8J will be on the regulations. Maybe I think we need to emphasize again that the regulations themselves must be in line with the spirit of 8J, maybe something like that, so that it's policy now, implementing policy of the bill itself. I don't know, but I thought it should be highlighted somehow. We may not do it now, maybe as we come back, because we have not had an opportunity to look at the regulations themselves here that operationalize the what's called the Act itself. Maybe we may have to look at that at some point, not now.
Fine. Let me once again, because maybe it's after the weekend, let's caution that we shouldn't be doing anything. I mean, this must be the portfolio committee's responsibility. So in our recommendations, and I don't have a problem with what everybody's saying, we should be saying that the relevant oversight authority must make sure, because we are not going to be in this formation after this, so we shouldn't give any work to this committee and raise expectations that it's going to exist in any form whatsoever beyond the 28th. All right. That deals with what we call legal status and governance. Are there any new introductions in that section that members want to bring on that one? No? Thank you very much. All right. The next heading, 14.4, we said corporate governance, but what we were really meaning, honorable members, was the role of the administration as opposed to the role of the board. That's what we were trying to capture in that one. So the COO, CFO, CEO, and everybody else. So the administration, for want of a better word. And then let's just go to 14.4.1. I really do think that that one is covered. You'll recall that we, at some point, we've made a firm recommendation to the interim board to do a forensic audit, not only on this, on everything else. So it's covered there. Happiness? Thank you very much. So that one will take. Even the second one, I suppose, fruitless, wasteful expenditure, it was covered in that interim report of ours. So those go out. When we say yes, it means we're deleting them. We already deleted 443 last week already, you'll recall. 444? Yes means take out. Look, you know, I mean, from where I'm sitting, it's a pity that Singh is not here. But even that 444 strictly is the responsibility of the accounting authority, strictly speaking. So maybe this whole heading of governance should just fall away because it's really the accounting authority. But 444 we're taking out, and it's covered anyway in our recommendations. Right. 445. That one is not covered anyway, I think. So, and then we'll find a heading for it. But let's talk to 445. Okay, you'll recall, honorable members, that when ICASA came to us, and again, I also saw this morning, I was reading something about that. ICASA came to us, they had requested that the chairperson, if I'm not mistaken, must specifically say to them that they have reversed that statement that they made. There was the statement around the not airing of the protests. That was the censorship issue that they were talking about at the time. So what we were really saying here is that if there's any matter that will, or that relates to censorship in any form whatsoever, those matters must be dealt with expeditiously. That's what we were trying to bring to your attention. You will do the English for it. So let's talk to 445. Does it belong here? Is it still required? Or can we put it, remember we are putting others into other when we find proper homes for them. But it doesn't stop us from talking about it. Anybody wants to say anything about the board and ICASA in terms of corrective actions, if necessary, around censorship and editorial decisions and so on? Anybody? Mahlangu?
Chair, thank you. This matter, according to me, should actually be going to the part of the board responsibilities that we were speaking about, because it's precisely their responsibility. That's what I would say, and I think we can only just perhaps improve any aspect of, but the location, I think, it should be going to the board matter.
Chair, I'm relieved to hear that you said that the SABC has withdrawn that particular policy of not showing destruction of public property. Oh, I thought you said
that was the request.
Yes, that's it. So I think it's got to stay in, Chair. It's exceptionally important. I mean, this is This is the crux of the matter here. The fact that there was censorship, and we say so in the last sentence, and the fact is we've got to ensure that for future elections, the one that's coming up in 2019, that the same policy isn't re-implemented or a similar policy. We need to ensure that the SABC reports news fairly and freely, and that the journalists can operate in an environment where they're not intimidated, and can, you know, and use their professional acronym to do so. So I think it's got to stay in, Chair. Yeah. So it's.
All right. Suggestion it stays as it is, and it goes to the top where we were talking about the board. Killian and then Mokoena.
Chair, I will not say I'm wondering. I would like to make a firm recommendation to say that I would like to refer it again to the Portfolio Committee on Communication, because we may have had the reports submitted to the committee, but just to ensure that everything is in place, I would like to recommend the following adjustment. The Portfolio Committee on Communication should invite the SABC Board and ICASA to ensure that all remaining issues related to policy implementation and or correction when necessary, with specific regard to alleged censorship and irregular editorial decisions taken. Full stop. So if we do that, then we are referring to the matters, and we're saying it can't just go away, but there must be a new presentation made to the Portfolio Committee so that everybody's on the same page.
Honourable Mokoena.
You know, under the heading of the minister, I raised an issue of the Chapter 9 advisory body thing, and then I was corrected later on. Apparently, the advisory body actually exists, because the advisory body is the one that advises the minister on policy in terms of content and editorial and so on and so forth, censorship and all those things. So I would then suggest that we put that in here, that the advisory body must be more effective, and that the Portfolio Committee of Communications must oversee that, and that they must implement that public participation thing that is in the Act, so that we have a more socially responsible editorial policy. So it's just the insertion of the advisory body, because nobody knows where this advisory body, what they've been doing for the past 2 or 3 years, and this is actually their competence. Thanks.
All right. 1446, once again. 1445. Yes, sir.
I want to support everything that Honourable Killian said, except the one word which was alleged. And I want to just allege censorship, I think you said. The fact is, it wasn't alleged, it happened. And there's many interviews. That's why there's a dispute between ICASA and the SABC, because there was censorship. It wasn't alleged. And, you know, Mr. Motseneng stated in several platforms why he was doing it. So the fact is there was censorship, and I think we mustn't beat around the bush. We must just say, as you've stated here, censorship. Thank you.
Chair, will...
No. Remember what we said. We'll put all these views. Tomorrow you'll have another bite at it. Because, I mean, this is really just stuff that we could clean up in 1 minute. So I'm not going to allow that now. We'll try and capture where there are divergent views and sort them out. 1446. You'll recall, honourable members, that we received evidence was submitted that said at some point people that were reporting to one line manager were then moved to another line manager, and that's what we were trying to do there. So we were saying, and I don't know where it fits in, but what we were alerting you to is that this practice of willy-nilly changing the organogram needs to be looked at. Nobody says you can't change the organogram, but it shouldn't be changed to fit purposes that are detrimental to the SABC. We were bringing it to your attention. And if you think that it needs to be crafted, you say so. If you think that we've sufficiently covered it in our deliberations so far, you say so, as we've done with the other two. But our intention was to say to you, it came to our attention, and we need to find a way of addressing it. So that is what we were saying on 1446. Does anybody want to talk to 1446? I see Mokwena's hand. Let's hear Mokwena.
No, Chair, it's covered in the, because it came as a result of the changing of the Memorandum of Incorporation, which then informed the delegation of authority and so on and so forth. So I think if we stick to the Memorandum of Incorporation changes, then that should be fine. Unless if we're saying we're keeping it for emphasis, then I would support that. Thanks, Chair.
All right. Keep it for emphasis. Is it sufficiently covered if we address the matters of legislation, separation of powers, and so on? That's the question. We're keeping it. Yes. Thank you. Killian.
Thank you, Chairperson. I think we should keep it, and I concur with that, but I would like to suggest that we insert the following at the beginning of the sentence to say, changes to the delegation of authority framework and haphazard changes to the reporting lines of the administrative staff of the SABC must be reviewed with the intended aim to strengthening corporate governance. We have a very serious challenge with the delegation of authority framework, which is not playing out to ensure good corporate governance, and I think we should make a firm stance. We should take a firm stance that it should be reviewed. Thank you.
1447, I think we spoke to this thing when we were talking about observations at some point, but really what we were saying is the process of vetting must not be underestimated, the vetting part of it, and then the involvement for stuff other than vetting must be frowned upon or must be revisited. Or I'm not sure, we should have, before we speak, let's just check what we said under observations, because I think we did cover this thing under observations at some point. But that's what we were saying here. And it'll probably be 1347 under observations, but I think we dealt with it at length under observations. But whilst members are talking to it, if you want to, I'll go and remind us what we said in observations. Anybody wants to talk to this matter? Van Dam, and hold on. Van Dam, Killian, Swartz. Chauke. Ma'am Van Dam?
Thanks, Chair. I think we need to be a little bit firmer here because the involvement of State Security Agency in what appeared to be, fighting battles on behalf of the executive management of the SABC is something we need to take seriously. So I'd suggest that we recommend that the Minister of State Security conducts an investigation and tables a report in Parliament detailing the reasons why the State Security Agency was involved at the SABC.
Chairperson, my recommendation would be the following, and that is that we say as follows: the SABC board should instruct management to provide clarity about the involvement of the State Security Agency or alleged involvement of the State Security Agency in the SABC in the corporation, and then we retain the second sentence: the task of vetting of senior employees of the SABC must be fast-tracked. Then I think we retain both. There's a sort of an investigation of what happened there, and secondly, we're also saying that the vetting of senior officials to be appointed is a very important matter, seeing that it is, that the it is a priority. Thank you, Chair.
Chair, I'm in agreement with the previous submissions, but possibly to add a sentence that the Portfolio Committee on Communications may wish to refer the matter to the Inspector General of Intelligence should there be found to be any irregular usage of SAA. Thank you, Chair.
I think Honorable Swart has covered us, but it must also be mentioned that the vetting of the senior staff is an important tool, so we cannot say it must not be there. Understand when they are appointed to positions, they are vetted, but it must not be used or abused, rather. The second one must stay. Yeah, it must stay. The second one must stay.
Chair, given the seriousness of the situation, I mean, I understand SSA vets employees, right? But they went further than that. They were intercepting communication, etc. Coupled with the fact that from early 2015 to very late 2016, there was no Inspector General of Intelligence at all. So on whose authority were they operating and all that needs to be investigated. And I would suggest that the Inspector General needs to do the investigation, not the SABC. I mean, as a matter of course, not the board. We need a, and he, it is a he, if I remember correctly, he must report back to the Portfolio Committee. And we must stipulate, and not the Portfolio Committee on State Security, because we will never get that report then as a public, but communications. So it's open and transparent. Else we won't know what happened, Chair, what transpired. It can't be the Portfolio Committee on State Security. Thank you.
We'll get the Inspector General to investigate and report to Parliament. Parliament will decide which committee it goes to, because remember he reports to Parliament and it's referred. But I take the sentiment that you're raising, sir. Mukwena, you wanted to be the last one.
Yeah, no, Chair, after we close this, because I want to add an additional point.
Okay, this one we close with. We're saying the vetting process must be intensified, specifically for senior managers, because it's important. We're saying any other matter must be investigated by the Inspector General and reported to Parliament. That's in essence what we cover there. All right, and then Honorable Mukwena says he has a brand new one that he wants to bring in. Yes, sir.
No, there's the emotional issue of local content and artist royalties and so on and so forth. And I think perhaps we should add in that a turnaround strategy must be installed to look particularly at local content and the role of and what happens to artist royalties. There's issues around needle time and all sorts of other things. So the Portfolio Committee on Communications must look at the royalties of artists, because I think we must concede that that's probably the one thing that Claudi is probably correct on, in that this country hasn't quite looked at that issue. So I think it is time.
It's fine. I'll keep on being the conscience of this committee. Did that matter arise in our evidence? You see, it can't be something that we're picking up from the general sentiment outside there. Remember, we're investigating matters that came before us. The 90%, was it before us? If it was, I'm saying we don't have a problem with it, but I'm just cautioning us from trying to, once again, address the ills of broadcasting in South Africa. Ours are specifically listen to people, call them verbally, in writing. If that matter is there, you can sponsor a proposal, and once again on Thursday when we meet again, we will look at it. I'm not saying you're right or wrong.
I'm just saying that Dr. Ngubane and Professor Maguve specifically spoke on that issue, on the 9010 issue, and they said that it's giving work to artists and so on and so forth.
No, as long as we don't pronounce on whether we support it or not. But I'm saying just you'll sponsor the resolution or the recommendation, and we'll argue it and finalize it on Thursday. Are you talking to the same one? Or is it a new one? I'm just trying to understand. It's fine. Is there no, it's fine. Does anybody else want to talk on the same one? If not, Singh will be the last one and we move on. Honorable Singh. Aye. Swartz, I beg your pardon.
Just the last suggestion is, and Mr. Mkwena also referred to the advisory board. Now, in terms of the Act, the advisory board can also advise on content. So he might want to add to his recommendation that this might be a role that the advisory board looks into in terms of its duties in terms of the Act. Thank you, Chair.
New one?
To say that we mustn't forget that this issue of the local content is at the center of the financial sustainability of SABC, and we do need to pronounce ourselves, not necessarily on whether we support it as a policy, but for those who will be doing the analysis to look at as well, because it's a major issue.
All right. That deals with 14.4? Yes? Yeah. 14.5, again, we spoke to accountability, and I mean, we've talked to this thing right through. And if we've covered it, we've covered it. If we've not, can I go to 14.4.1? 14.5.1, I beg your pardon. Again, I mean, that one is as straightforward as it is, that I'm saying there, that there was clear evidence of misleading, and now I'm not saying deliberately or otherwise, but you can't have two so different versions of the same story. And what we were basically saying here was that matter must be looked at. We did get a legal opinion from our good friends, the lawyers there, in terms of what the sanctions are for people who have misled Parliament, anybody who has misled Parliament. So all we were saying there is that we cannot not say anything about it. That was the intention of 14.5.1. Anybody wants to talk to 14.5.1? Van Dam and then Killian.
Thanks, Chair. Can we be explicit in that section about which legislation will rely on in this regard about misleading Parliament? And that's the powers, privileges, and immunities of Parliament and Provincial Legislatures Act, specifically Section 17.2, which says that if anyone deceives a House of Parliament, this person commits an offence and is liable to fine or imprisonment for a period not exceeding 2 years. So can we be explicit and just include that section? Thanks, Chair.
Chairperson. Yes, Chairperson, thank you very much. I would like to suggest the following, that we actually, that we again look at which entity should do this. And my recommendation would be that the evidence leader and Parliament Legal Services should compile a list of individuals who could be guilty of providing misleading or false information or testimony to Parliament in terms of Section 17.2 of the Powers and Privileges Act, the whole of that. And then to say within, now the period, we must be realistic. Should we say within 60 days from adoption of the report? So that we have sort of an opportunity to have a timeline to it, and we also have a body that will drive this process. Thank you, Chair.
All right. You see, Nina, where I come from, né, if you raise your hand after somebody spoke, it's no longer an original idea. Somebody said something, you want to raise it, but here we will do that because seeing Swartz and Kubisa, Swartz and Kubisa on 14.4.1.
Thank you, Chair. The appropriate sanctions must be implemented. I don't think you can say that. You've got to have an inquiry before you can have sanctions. So they must be identified, and held accountable. Just that phrasing, because you're assuming that they are guilty. But secondly, the issue which I raised about the one witness that gave evidence about the 100 million, and then the minister indicated, well, that's a breach of the Corruption Act. In other words, shoot the messenger. Now, we need to also say, but any persons that have given evidence in good bona fide will be protected, because it's not correct. That witness, Shishudu, cannot be prosecuted for what he told us here. He is protected. I don't know if I'm laboring the point, but the minister seemed to take a lot of time to say, well, he will now be prosecuted because he gave us that information.
I'm just wondering, should we be the defenders? And I hear what you're saying. You're absolutely correct, what you're saying. But I would imagine that, yeah, that's the point that I'm making, that it goes without saying, and then everybody reserves the right to corrective action if things are done wrong. I just don't know that we should be, because that's one, and I'm not saying it's right or wrong, but consider it. Has everybody spoken on this matter? Yes. Oh, Mr. Waters.
Chair, just on what the...
Oh, no, no, just Kubisa, beg your pardon.
That's fine.
Prof and then Waters. Sorry, Bob.
It was scary, Chair, when you said it's like we're not original. So, Chair, I wanted to say the legal team should also assist us, because there might be other legislation over and above the Powers and Privileges Immunities Act. So we rely on the legal team to assist us if there is any other legislation that they want to add and which they deem fit with regard to this matter in particular.
Chair, I hear what Honourable Swat's saying about, you can't find people guilty before you've actually conducted an investigation. But the sentence does start with witnesses found guilty. So it's a proviso. Must be identified, and the appropriate sanctions must be applied. So I think if they're found guilty, thank you.
All right. Just playing devil's advocate, I agree with the sentiment. Just from a practical point of view, how will we be satisfied that Vanara and the legal team have covered everybody? Because we're saying Vanara and the legal team must look at everybody. I'm just thinking out aloud, because if they identified 5 and there's 6, or they identified 6, I don't know. I'm saying we must be able to measure these things. I don't know how we're going to do that, but unless offline, and we're saying to ourselves here that in terms of, if we're giving that recommendation to the legal team and Vanara, surely it should be our responsibility at least to give them some of the evidence. I mean, they were part of the team. I'm just wondering, will they cover everybody? How do they practicalize what we are saying? It doesn't have to be a recommendation, but how do they practicalize it? Kwankwa and then Killian, and then Swartz.
I'm not going to answer your question, if you don't mind. I think that, coming back to that sentence, I wanted to bring to your attention to that sentence before you made your input. I think Honorable Waters is right. The sentence is found guilty, but I think the part which says must be identified then assumes that they have not been identified yet, and yet we're saying they are guilty. I think we must just tidy up that sentence towards the end so that it doesn't contradict itself. Thank you.
Chairperson, my suggestion would be that we just give the responsibility to them to identify those who have actually contradicted each other, and that they then submit the list to Parliament, and Parliament will probably refer it to the Powers and Privileges Committee for further investigation. Because then that process, they can then go into the details. Thank you.
We will not exist anymore as an ad hoc committee, so I'm in agreement with that. Thank you, Chair.
The point that I'm making, that we won't be here, but it's a matter important enough that can't be left unattended to Vanara and to the legal team. It can't be left unattended. 1452, I think we dealt with this one. What we were saying is there must be no ambiguity that the SABC accounts to Parliament. That was the point. I'm not sure if we've covered it anywhere else. I thought we covered it under governance. Killian.
Can we retain it here as well, Chairperson? I think it's a very important matter because there was certainly a move in the last 6 to 8 years. I think we should say the following. The SABC is the public broadcaster and is as a company listed in the PFMA, must be held accountable by Parliament. So the matter is not how big the funding is, as you have said earlier. It's not whether we, from the public purse, allocates R1 to it is the public broadcaster listed in the PFMA. That is the issue, and they are therefore accountable to Parliament.
$14.53, is it necessary, is it not necessary? You remember we had the big fight about summons. Basically what we're saying here, that there should never be a situation where Parliament must issue summons. That's what we were trying to say. That no document should be withheld from Parliament. You can argue about how we deal with it, but there can never be a situation where Parliament must summons anybody for a document. That was the point that we were making there. Happy?
Yes, Chair.
14.45, I think we can take out. We've dealt with it to death. The compliance with PFMA and all those things, contract management. We've dealt with it even with the board. 14.54. Avuloliwe?
Thanks, Chair. Chair, I agree with the trust of that point, but I want to suggest that we allocate that responsibility to SCOPA and the Portfolio Committee.
Must be adhered to and monitored by the Portfolio Committee and SCOPA. We'll just add those 2 lines to it. Oh, all right. Anything else under accountability, new business? No? Yeah? There's other. Remember, there's other. When we think about something, we can put it to other. I'm sorry. Just to repeat, I'm saying it emanated from the evidence from the SABC 8 in particular, and it could have come from Right to Know and other people. All we're saying is that the standards of journalism, editorial independence, must at all times be maintained at the highest standards. Now, I don't know if it's necessary for us to put it there. I thought it was a standard practice. If you want to put it there, you're going to put it there, it's fine. Matlangu, and then Van Dam, and then Kilian.
Chair, it is an appropriate statement, and I think even as we'll be looking at the problem statement, that matter will also feature. So it's an appropriate matter, and I think it was just unfortunate that when we got the evidence here, some board members actually did not know about it. So it's crucial that it's a very important one. That's what makes the SABC a national broadcaster as against a state broadcaster. So it's a very important one.
I'd like to add a firm recommendation that the revised editorial, it's linked to 14.61, but I suppose it would be its own bullet points. Should I leave it? Okay, cool.
Thank you, Chairperson. I would like to recommend the following, that we say as the public broadcaster established in terms of the Broadcasting Act, comma, The SABC must at all times adhere to the highest standards of journalism, must in terms of the Charter always adhere to the highest standards of journalism, with editorial independence being uppermost. So then we reinforce the point, it's the Charter that must be upheld, and it is the public broadcaster established in terms of the Broadcasting Act. Thank you, Chair.
All right, 1462, again, is it necessary? Has it been covered somewhere else? Don't we need it? What we were saying, in summary, was that in its operations, the board must make sure that the SABC regains the confidence of South Africans in terms of reliability and credibility. That's what we were saying in essence, that in our ongoing operations, let's regain reliability and credibility in the eyes of the audience. Vanda?
Thanks, Chair. I think this is actually where my point comes in, about gaining the public's confidence. So I would like to suggest that we say that the revised editorial policy is withdrawn and public consultation, thorough public consultation is conducted. And I think that then will then ensure that the audience gains confidence in the SABC.
You have some benefit that we don't have. The editorial policy, is it somewhere in the pipeline, or where is it?
The editorial policy,
so that you can just, because when we adopt it, we must adopt something that we think we can defend. That's why I'm saying you should just give us some idea what you're talking about, and then we'll agree very briefly. What is this revised?
Okay, so there was a revised editorial policy discussed earlier in 2016. It's under dispute, but the facts show that there was not proper public consultation. Yes, and I think there were several witnesses who actually spoke to how there wasn't sufficient public consultation. I think it was ICASA, Media Monitoring Africa, and also the SABC 8. So there wasn't proper consultation before that editorial policy was finalized. So I'm suggesting that we say that that revised editorial policy, where there wasn't proper consultation, is withdrawn, and the old editorial policy is in place until they've conducted proper public consultation.
Policy must be revisited, is what I would say, by the portfolio committee, because everything else makes us. But I'm saying that would be my point. No, it's fine. She's our agent there in that committee. Yes, yeah. Swartz, not Swartz. You want to say something, Swartz? No. You covered. All right?
Chairperson, I'm sorry, Chairperson. No, I'm covered with what you have said about the Portfolio Committee, because I do remember that we also listed this matter under the board. We referred to policies that were not processed regularly, should be reviewed, etc. But if we give this specific one to the Portfolio Committee, I think we are covered.
Sorry, just to be clear, what do you mean give it to the Portfolio Committee?
I'm saying the chairperson has said it is the responsibility. So we must just say that the Portfolio Committee on Communication must ensure that the policy be reviewed, or that they investigate the review, because the reason is, Chairperson, there is a dispute. Some say there was adequate public participation, some say there was not. So what process was followed when that was reviewed?
No. That's why I said ninga emotional. I said, let's agree that that policy that Van Damme has explained to us must be revisited by the Portfolio Committee, and they would look at all these matters. And we've got members here that will have a background to why we've referred it to that committee. Let's take Van Damme and Chauke.
Thanks, Chair. I mean, I can understand saying it must be dealt with by the Portfolio Committee, but ultimately it's a responsibility of the board. So the former board actually failed to conduct a thorough public consultation. So if there is an instruction, it should go to the interim board, not necessarily the Portfolio Committee.
No, I was not going to agree with this whole discussion, because it seems we are now opening up a debate that is on in a portfolio committee and wants to use this platform, in fact, to instruct what must happen in the committee. I was going to look at the principle itself of what we have raised here in the report, rather than, dealing with that detail. It does not, in fact, arise here. If you are to look at what you are dealing with the mandate of the SABC generally. What is it that it must do to the public? So I thought that we add anything. If we don't have anything to add, we leave it as it is, Chair, rather than bringing in those issues. Those issues are quite far from what we are raising in the document here. Yes, that's correct. No, my proposal was that we leave it as it is. Then we can then have an opening for this what you call particular point, which is the role of the board, obvious. Under the role of the board, I think that's what it can come in. You can't put it under this what you call 14.62.
No, we're agreeing. We're agreeing. We are saying that let the board, as a separate hearing, that's fine. Did you want to say something, Honourable Swartz, on this matter?
Yes, Chair, one needs to remember that the Minister gave evidence on this issue and indicated that the Act is clear, that editorial policy does not have to be provided to Parliament, whether rightly or wrongly. But the Portfolio Committee can exercise its oversight role to look into that. So she made she set out the law in that regard. So we need to be mindful in a balanced approach of what she said on this issue of the editorial policy, that she'd never been invited by the committee, communications to brief them either, and we're not sure about that, so you can help us. But I think I'm in agreement, Chair, with the proposal going forward.
All right, the last point on that matter. We were saying that the board must ensure that an environment of environment free of, not fear, it should be fear. Free of fear and intimidation or abuse of power must prevail at the broadcaster. Again, stemming from the fact that people said they were intimidated. So we were just saying, look to the board, go and make this an employer of choice. That's what we were saying in essence. Comments? Van Dam? And Kubisa? You'll follow? Yes, Van Dam? And
Oh, sorry. Thanks, Chair. Remember when the SABC 8 were here, they spoke about enforcers. So people who were beholden to the COO and implemented his decisions, his henchmen, or if you'd like. And I see that they provided that list in their further submission to the committee. So can we add that in order to make sure that it's a free and fair working environment, free of abuse and intimidation, can we include that those specific people, the enforcers that were provided to us as we requested, that there be an investigation into the appointment process at the SABC? Yes, the board, yeah.
Chair, I wanted to say this is critical to the functions of the SAPC. And I wanted to also to add Parliament in, because at the end of the day, Parliament must ensure that something is done, that this is done, and it is done within policy. And no one is coerced, no one lives under fear when it comes to reporting or delivering news. So Parliament must be put in here so that Parliament is able to see that this is done. Of course, it will be the portfolio committee.
Deal with the issue of the raising of the morale of the staff, Chair, because vis-a-vis under fear, intimidation, the board has that responsibility again to raise the morale of the staff. Maybe we need to find a line that deal with that particular area within this line. I don't know how we can add it, but I think it's an area that will definitely require an agent attention of the board, because with all the intimidations that have gone through, I'll take it, Chair, that the kind of staff we have now, the morale will be very, very low. So I think it's important that the board sort of take up this matter as a matter of urgent. Thanks, Chair.
Chair, a separate bullet, we need to refer to the threats against the SABC 8 and any other particular person. That would be a separate bullet. And my wording would be, should any further death threats be made or acts of violence be perpetrated against any member of the SABC 8 or any other staff member relating to the situation at the corporation, and we need to recommend police protection or police investigation as a matter of urgency, so that we put it there. We've already basically said that, but I think it's important for us to mention it in this report. So it's not only the SABC 8, any other person as well.
Will you make a recommendation to the board?
The board and the portfolio committee. No, absolutely, the board and the portfolio committee.
And also just in reaction to the allegations that there are some people who are running the SABC from outside, perhaps we should make a recommendation that the board must also investigate that as an urgent matter, that they must investigate such practice. We got that from, it was mentioned. No, Honorable Nkwangwa mentioned it. And no, but the. No, but I.
Honourable members, yeah, no, I'm hearing what you're saying. Remember we started by, no, hold on, Chauke. Remember we started by saying journalistic standards must be at their highest. I thought that would cover influence from any, and we know that it might be whatever. You know, this report we'll have to defend. We are going to have to defend this report after the 28th. Now, I don't have a problem, but all I'm saying is when we write our report, it must be as tight as possible. That's all that I'm saying. But let's take your point. The suggestion you're making, you're saying, is that we must investigate outside influences. It's fine. In terms of influencing journalists. Yeah, but honourable members, hold on. No, but hold on, honourable members. We're talking about journalistic ethics here. This is the heading we're looking at, journalistic ethics. Now that could come as a matter under other, it's fine. But this was journalistic ethics that we were talking about. It's fine. No, let me allow him, he's done. He's suggesting that we put an item that says, are you done, sir? Yeah. No, hold on. Please listen to him. Whether you disagree, listen to him. His point was, let's put a bullet point that says no outside influence. In essence, that's what he was saying. Mukwena. Now let's take Nkwankwa, let's take Waters, and let's take Chauke on this matter.
Chairperson, as much as I'd like that to be included in the report, but my discomfort with that is that it's an allegation that we never investigated. So it's untested. As much as I'd like to sit here and say I told you about it in light of what happened yesterday, but we didn't investigate it, so it has no place in the report. Yes. Yeah, well, I was calling for us to investigate. That opportunity was closed.
We don't have investigative powers, it's fine. No, hold on. No, let us not deteriorate. We're almost at the finishing line. Waters?
He suggested a paragraph about intimidation and death threats and violence. But I would like...
Before you come there...
Okay, yeah, let me just...
let's just deal with the one that was raised by Mukwena. Chauke, were you going to talk to Mukwena one?
No, I was going to say, Chair, that maybe what informs the point of Honorable Mukwena is the fact that currently the SABC is in the autopilot mode. There's no leadership, obvious. Anyone can do as they want there. So we may not want to put it as an item, by the way, but emphasize on matters that the interim board must do with immediate effect to stabilize the organization. Because once you stabilize the organization, you then deal with these outside forces. And outside forces may be many. It may be political, it may be what. But that's part of the mandate that we must give to the interim board to stabilize the organization rather than putting allegations that are not tested. Nkongwa, I'm on the floor. You don't speak when I'm on the floor, Nkongwa. You keep quiet. You know. So I thought that, Chair, within that package of the interim, it's very important to stabilize in the absence of accounting authority and leadership. So I think that's how we can deal with it. Thank you.
Can we live with it, Baba? Thank you. We did talk about stabilize when we spoke about the board. Honourable Waters, you can go back to that one.
Thank you, Chair. Chair, Honourable Swart's suggestion was that we include death threats and violence. It shouldn't happen to the SABC 8 or any other journalist. I'd like to just include intimidation there as well, because it doesn't necessarily have to be violent intimidation. It could be verbal, it could be undercurrent. So I think we should include intimidation. So it's death threats, violence, or intimidation. Thanks.
It's there, 1446, we were talking about an environment. No, he was adding to that one. Yeah. Do you want to put it in both of them? Because no, I think your point is valid, Waters. It was in 1446. Do you want to put it in 40? It's fine. It's fine. It's fine. All right. All right. Fine. All right. 1447. 1446 we're done. There's nothing else. News. Mukwena's one will be incorporated or was incorporated in wherever. That's yeah. Not wherever, man. I'm sorry, man. When we were dealing with the board, Mukwena understands me. 1447. We said 14.7. We have parliamentary oversight. Really, we were trying to identify matters, and we've already identified few. We were trying to identify matters specific to the portfolio committee on communications that will assist in stabilizing the SABC. The first point, we say they must ensure that legislative framework governing the operations is finalized urgently. I think we spoke about that when we were talking about under legislation and whatever there on top. I think we dealt with it. We decided that you see, no, but we'll talk about it tomorrow because we forgot. But yeah, that's it, yes. We had said that whatever we do, we must make sure that the Public Broadcasting Act is supreme and any other regulation or whatever the case might be must be aligned to the Act. That's what we had said under governance. Now we can put it under governance and repeat it under portfolio oversight, because that's what we were trying to say here, basically. If we agreed with that on top, we can just rephrase it here. On 14.47, Koza and then Van Dam.
Chair, I'm of the strong view that we would probably have not accomplished our mission successfully if we do not have a point under the need for strengthening the oversight and training our own members, the members of parliament, on oversight and separation of powers. There was damning evidence on how the parliamentary committee also took part sometimes and really in the failings of SABC, the committee also was found to be, not playing its role that it is supposed to do. So I don't know how do we phrase it, Chair, but I do think that we do need to come up with something that is sensitizing even Parliament, that there is a need to train our own members of Parliament, even if we have all of us go for a one-day workshop where we really understand what it means to perform oversight and what is separation of powers. How do we ensure that that happens when we are performing our oversight in different committees? I don't know, Chair, but I'm just saying it might be useful.
Can I restrict comment on that one, because that's a new point. We were dealing with 14.47 now. We'll come back to that point. So if these hands were in relation to that one, can we refer it to then? Yeah, it is relevant. That's why I'm saying it'll be a new point that we will discuss. We either delete, accept, strengthen 1447 as it is now. What are people saying on 1471? Yes, Vanda?
Chair, I thought this section was speaking to the Broadcasting Amendment Bill because it deals with, it's quite clearly about the legislative framework of the SABC. Now, we discussed this matter at the last meeting, and I don't think we'd finalized it, about whether or not we're going to recommend that the Broadcasting Amendment Bill, which seeks to take away Parliament's powers in appointing board members, should be withdrawn. I think, did we finalize? I remember the last point was that we asked for a legal opinion to be provided on that bill, and then we were going to come up with a recommendation. So we left it hanging. We didn't decide whether or not that would be a recommendation. But if we have, then if we've decided that that's a recommendation, then I'm happy.
Members can talk to it, and that's why it's difficult now, but we could look at it tomorrow. My recollection was that that matter must be referred to the Portfolio Committee because, remember, there was an argument whether it was in the NCOP or the NA or whether it was withdrawn. Ultimately, we suggested that PBA is supreme, and everything related to that must, that including everything else, the Portfolio Committee must make sure happens. We can revisit it when we redistribute the document tomorrow, but that was the sentiment that was there, and therefore it will include any bill that has been introduced to Parliament or otherwise. That, I thought, is what we were saying. And what we were trying to say here was, in the spirit of that, if there was these things, it must be finalized urgently. Because that one was trying to dilute it, I think, the one that was introduced. And therefore, we were saying these matters must be resolved, bearing in mind that the Act, as the Public Broadcasting Act, must be the Supreme Act. That's what we were intending to say here. If this thing is very confusing, we can always remove it and introduce something else that is going to strengthen it, because there's nothing that says they must stay there as they are. It seems to be raising confusion. Maybe we must remove it and introduce something else. Singh, Chauke, and then Van Damme, second bite. Swart.
Call me Smith today, Chair, it's easy.
No, in our discussion last week, Chair.
No, Swarts first. Swarts, Chauke, Van Damme. Yo, allemaal wil praat. Okay, now hold on, let me take notes.
We had a broad discussion.
Van Damme, Chauke, sorry, Swarts. Somebody here want to speak? Loliwe.
Ready?
No? Everybody will talk, don't worry. Loliwe, Mukwena. Sure. Suga. Let's start here and everybody talks on it. Let's start here. You got 2 minutes.
The right mic. Chairperson, I think it is an important matter that we have said we will express ourselves because we have seen what has gone wrong because of an amended MOI, which we believe was not in line with the Broadcasting Act. But the problem is that we should say that the Portfolio Committee should we can't say to them that they must reject the Act. They will work through the Act, but they must do so bearing in mind the constitutional and legislative principles that guide the public broadcaster. So I would rather work for those, in our sort of recommendation, that we don't say to them they cannot amend. We have actually discussed it a little earlier. You can't cast a piece of legislation in stone. You have to be able to adjust specific clauses which may be conflicting or sort of create uncertainties. But I think as long as we can say that it must abide by the principles. Yeah, thank you.
Thanks, Chair. Chair, understanding the processes that a bill follows, I think when we were debating this, because it's not coming up for the first time, we agreed that the Portfolio Committee is better placed to deal with this matter rather than us clouding our recommendations.
Swart?
Thank you, Chair. Just briefly, take us back to the 13th of June meeting with the Portfolio Committee, where the Minister indicated the Companies Act trumps the Broadcasting Act, and the Portfolio Committee agreed with that view and supported the removal of those 3 board members. We now know that the Broadcasting Amendment Bill is before that Portfolio Committee, which will take the power of Parliament away to appoint or remove board members. So we need to express ourselves. Our opinion says that the Broadcasting Act trumps the Companies Act as of now. But if that bill passes, and it's not for us to say, we can't bind Parliament, but we should express ourselves to say, if that bill passes, it will obviously change our view. So we need to defer to the other committee, but to indicate on the evidence that we've heard, we would like that position to remain, and that's what Mr. Mokoena said, should, as far as possible, remain the same, and that the power of Parliament to appoint and remove board members should not be removed. So we can express ourselves on that. Whether other portfolio committees want to accept that or not is, and we can't bind them. I think that's what Mr. Chauke was concerned about. Mr. Chauke, and you obviously expressed it, but his concerns were about our expression on this bill. He said, you know, that it's not before us as such.
Okay. I'm trying to think because remember we're doing a real time here. As we're typing here, we're saying that we reaffirm that the Public Broadcasting Act is the supreme, and that any legislation before it or whatever must not weaken or change that position substantially. That's what we are saying. All right, so that we can do it. You want to still speak on the matter, Honorable Mokoena? We're going around. If you don't want to, it's fine. You don't have to.
No, I'm partly covered, except that in our observations, we do make the point that the minister is trying to centralize power. And I think in line with that observation, we must then say that in investigating the amendment to the bill, to the Broadcast Act itself, because remember we had that discussion and said that the Broadcasting Act is in front of the Portfolio Committee right now as we speak, and that the minister is trying to amend the Broadcasting Act in order to give some of the powers of firing and hiring to herself. So in investigating that amendment, we must consider it in line with her centralizing power to her office. That is the recommendation that we must make, because now I would have directly said that they must reject those things, but we can't say that. So let's ask them to investigate the possibility of centralizing power in the minister's office.
Ask the Portfolio Committee. No, I'm trying to understand you. No, it's fine.
Yeah, just wanted to add that in expediting this task, the Portfolio Committee must consider also take into cognizance the constitutional imperatives and any other recommendations made by the Ad hoc Committee on this matter. Thank you.
Chair, thank you. In a way, colleague Swartz have covered me on what he raised about the occurrences already in the portfolio. I am not sure whether it was in this meeting. Yes, I was not sure whether it was in this meeting where the issue was raised that those members who were dismissed by members, including the committee, are actually at court. If they are at court, they are going to take a particular stance. In that case, the likelihood they may use the Companies Act as their defense, and now there's going to be a contradiction. So I'm just raising that matter that somewhere we will need to manage this aspect properly, but I can't agree more with the colleagues that have raised that in this case, the Broadcasting Act trumps the Companies Act. Thank you.
Just briefly, Chair, I agree with Honourable Swart that we can't dictate to the Portfolio Committee on what stance to take with this amendment bill, but we can give our opinion. And it does need to be stressed that if they support the bill, they're curtailing Parliament's powers for oversight of the SABC and who to appoint to the board. And they are, as has been said, centralizing that power within the ministry. And that goes against the principles that we've talked about. So I think we do need to stress that quite clearly.
Thanks, Chair. I think I'm covered by what colleagues said earlier. While I would have preferred if we'd made a recommendation about the bill, there is a point to be made that we should allow the committee to do its work and go through the processes of Parliament in making legislation. And I agree that then we must say that in the Broadcasting Act is the supreme law governing the SABC, and that any amendments cannot go against the spirit of the Broadcasting Act and must be constitutional.
Chairperson, I think we've deployed 2 cadres in this committee to do that for us in the Portfolio Committee on Communication, so I'm not going to repeat what they say. I agree entirely.
Chair, this was my point that I was raising last week, and I think colleagues have covered it, to refer the matter to the Portfolio Committee. The Portfolio Committee has a power either to reject that whole bill or to amend it further. I mean, that is why it's before the committee. So my take is that as long as we have not gone into the merit of the bill itself in this portfolio, in this ad hoc committee, therefore we can easily refer this attention to put the attention to the Portfolio Committee to deal with such. But again, we need to understand, Chair, that once the bill leaves Cabinet, it's a Cabinet bill that comes to Parliament, because it gets approval by Cabinet, and then therefore Parliament, obviously, has the total right to deal with the bill as it wishes. You know, it can reject the whole thing, or it can amend it accordingly. You know, so we must not just put it as if we say throw away that bill as it is. You know, they must apply their mind properly. There will be public hearing in the process, but they will definitely have to work within the spirit and the letter of the Broadcasting Act. And if it's that the position, I'm very fine, Chair, with that. And then the committee, I think it will be give it the necessary support. But the point that is raised by Honorable Khoza, Chair, about capacity, I wanted to sneak it in, but it's fine. It's fine.
No, that one is coming. That one is coming. Yeah, no, we said we'll get to new business. So we're happy with that one. Everybody has a chance to speak. 1472. I think that's obvious. I mean, it's our normal practice now that committees do quarterly reports. I mean, we don't have to say it here. It's normal business of all portfolio committees.
Yes, I agree with that.
Yeah. All right. So say I keep.
Yeah.
No, but I'm saying it's what portfolio committees should be doing. You want to leave it there just to emphasize it?
Chair, I think we should leave it there. We did a lot of human rights, human resources issues. Yeah. I think we should.
It's fine. All right.
It's not,
Okay. All right. So yeah. So we just saying to the portfolio committee that they must focus on these. That's fine. And on that one, you recall we said, and this is oversight. Remember we dealt with perceived or real or alleged or whatever you want to call it, interference from political parties and any other people. What we're saying here is that the board and the portfolio committee must be vigilant. This type of action must be condemned, and it must be brought to the attention of Parliament so that it can be dealt with. That's what we were saying in essence there, that whether it's real or perceived, but it's the role of the accounting authority to say, I'm being bullied by Vincent. And the portfolio committee must then go and help the board, because they're supposed to be the protectors of the board in that regard. That's all we're saying. I mean, it doesn't have to be too much discussion on this matter. Okay, let's take Swartz, let's take Waters, and let's take Chauke. On this matter.
Yes, Chair. no, I'm in agreement. We need to refer to it. Whether this is strong enough is something we need to look at. But if you look at 14.8.6, surely that should come in here then as well. 14.8.6 refers to political interference as well. And I'm not sure. That seems to be a bit of a contradiction there. So when we get to 14.8.6, we must consider what we're saying here.
14.8 is a different point. Totally different. They're only talking about contradictory evidence.
Okay, but then one needs to just, because when I read the two, I linked the two. But let's deal with 14.7.3 then. Thank you. So far, I want a reference to that here, whether the reporting should be to the board, definitely to Parliament as well. Yes.
Chair, I think we do need to strengthen it. I agree with Honourable Swart. So if, for example, an individual has been found to have, been influencing the SABC in any way politically, and they've transgressed any laws of the country, then charges must be laid against those people. We can't just condemn. I mean, yeah, okay, it's a part of the process, but we need to lay charges against those people. I think that needs to be stated very clearly up front. The board's investigating it. No, I thought. Oh yes. Well, then Parliament must do that. You've got you've got the ethics, code of ethics. You've got the executive ethics code, and you've also got the. Sorry, I've lost all my sheets here. You've got the Powers and Privileges Act, which comes into being. You've got the Executive Ethics Code and the Constitution, and the PFMA, in fact, if they've transgressed that in any way. So I think we must speak very clear and say that if anyone's transgressed any of those laws, or any law, in fact, charges must be laid against them.
Must be exposed by the board, and Parliament must then
Yes,
decide.
yeah, I think so. Yeah.
No, Chair, the issue that we're dealing with here mostly is to deal with all those political interference and to expose them. Now, let's go back, Chair, and look at what has been happening. Yeah, what has been happening is that there's an element that we are living outside, and that's element of public, the role of the public in helping. You'll recall, Chair, that there's been a standoff. Members of the public mobilized against, and those who were for, when things were not, in fact, done properly at SABC. So members of the public have a role, in fact, to play in helping to expose, not to be used, in fact, the way we have seen it before, but helping them to safeguard and to protect SABC. Because the public broadcaster, I think the public has a particular role to play there. So I wanted to include a line, in fact, that deals with including members of the public in exposing any, a interference or any outside influence outside the ambits of what is required of the SABC. I thought that we are not drawing in the public throughout the hearings between us, Parliament, Portfolio Committee, but members of the public, how do we bring them to understand, in fact, even to appreciate these assets called the SABC, So I thought that somehow I'm throwing this line, Chair, to add on it, but we may find anywhere as we engage where public play a critical role in making sure that a public broadcaster like this one is protected, not only by Parliament, but even members of the public have a responsibility to play in making sure that they support the public broadcaster throughout, We have seen how public can be what's called manipulated and used, by the way, in defending wrong things that were happening at SABC.
All right. Thank you. Honourable, that deals with it. And Honourable Khoza, you can introduce your subjects, the new one that you wanted to bring in. Bearing in mind, just look at 14.8.3 first before you go there, and then you can introduce the matter you wanted to introduce. I'm not sure if it's covered in 14.8.3.
Chair, I think mine is more specific because it's going further. It's saying there has to either be a workshop or some kind of training of members, because we all assume that members know what to do, and the truth is we have not really gone through this process of really dedicating enough resources for members to be capacitated in this area of oversight. Specifically in terms of performing effective oversight.
All right. The last point, honorable member, or not the last point, 14.8, we called it other because these are the things that we just couldn't find a home for them. 14.8.1, we've dealt with it. Yes, last week, yeah. 14.8.2, we dealt with it last week. 14.8.3, anybody wants to talk about it? Okay, and again, and that was a portfolio committee responsibility, and I think we've dealt with it previously when we were dealing with the role and responsibilities. I think that one is dealt with in today's business, no? Okay. Okay, 14.8.4. Can we, yeah, 14.8.4, the next page, we're not done yet, ma'am. In light of where are these people, Vanara and the legal team, we gave you a job to look at misleading. Can we also give you this job where we are saying that the professor must pay us all our legal costs out of his pocket? Can we give you that responsibility? Are we happy that we give that to legal? Because there's nothing we can. All we are saying is the Desai judgment said he must pay. We must then give him the bill to pay our legal costs. Swat.
Amendment there, just to say after chairperson's personal funds, just to say chairperson in his personal capacity as per the relevant court order. Thank you.
14.8.4 we've dealt with now. Yes, I'm saying on 14.8.5, we are saying that we're not only talking about, here we are saying the lawyers and attorneys that gave advice. That's what we are saying. You want to talk to that one? Yes, sir.
Chair, you received this letter this morning from the attorneys that I think it would be opportune to address that letter now or just to file it or something. Well, Chair, just that there are certain demands that are put here, but at least that the letter is tabled before us as a portfolio committee, and we obviously, you've got certain privilege in Parliament as to what you say, and that the lawyers will be addressing that. Is that so that you're pertaining to this letter as well, Chair? Thank you.
Just to say that we responded to them accordingly, said to them that we will not be demanded to what to do. Parliament will act as it sees appropriate. When we acknowledged it, we said it to them, that we'll act as we deem appropriate, but we will not be dictated to as Parliament. So the legal team will deal with that matter.
On that note, with regard to the lawyers, is that the same lawyers that were reported to in one of the newspapers that in fact they were struck off the roll and therefore it's not them?
No, I don't want you to go there.
No.
Don't even open that debate.
Okay, no. So I thought if it was them, Chair, I was going to charge them, in fact, now.
Fortunately, I know Chauke very well. Yeah, but the lawyer, but we're saying we're dropping that with the legal team. Are you with us? Are you guys with us? 14.8.5. Yes, sir.
Even the wording is 8.5 there, or you're just referring it to them? Because I'm...
No, if you want to change the wording specifically, you can change it, sir.
I must face all possible sanctions. That presumes that I think that consequences is a better word.
Yes, sir.
Can I just, maybe for purpose of clarity, the point that I was raising, Chair, you have just ruled me out of order on it, but I think the point I want to understand is that if that is true, Chair, what we have read and it's what we understand about the said lawyers, then I think we'll definitely have to find time, Chair, to look at this whole issue, because if it is true, it means that they have committed fraud somehow and they are fraudulent themselves. If they've been struck off the roll and they're acting on behalf of SABC, there's a bigger crime that will have to be investigated here. So I'm saying that let the legal team sit with you, deal with that, but let this matter be seriously looked at. Next week when we meet, let us get the report of the status of this company and the people who have written to us. If it is them that they are found to have been struck off the roll and they've been appointed by the SABC without declaring that, in fact, they are null and void, it's something else that we'll have to deal with. So I'm saying let's note it next week when we meet, Chair, because I've read their letter, by the way, myself in the morning. Let us reflect on this thing and take a position next week, not now. Thank you.
We're not meeting next week.
The next meeting that we're going to meet, Chair.
Okay. The last point on this document, it falls with the category of conflicting recommendations, but I know you wanted to say something, Mr. Swartz.
Chair, we would just need to tighten it because it doesn't seem to fit there. We would need to add a sentence to say this contradiction needs to be investigated further, and maybe slot it in under those sections where we're speaking about contradictions. Thank you, Chair.
Remember, we had given it to those people, but we can put that in because we're referring it to the legal team to run with it, because we don't have the capacity.
But it's just ending off with that statement, which doesn't seem to, and so it follows up that aspect. Thank you, Chair.
Ma'am Van Dam?
We are 1486, right? Sorry, are we at 1486? Am I correct? Yes. Yes. Sorry, I really did not understand what that sentence meant. I think.
Remember, on the last Friday, witness Ngubane said there was no political interference, and witness Shabalala said there was political interference. This is what basically saying. That's what I'm saying. It's part of those where they were contradicting, and the legal team must investigate it, as we had agreed earlier on. All right. That then. No. We'll take Waters, and then we'll take Mahlangu. Waters.
Chair, 1487, I would like to suggest, Chair, given the fact that Dr. Ben Gubani is the chairperson of the ESCOM board as well, and given the fact that we've all stated that we believe he gave misleading information to us, should we not be suggesting that the Portfolio Committee on Public Enterprises investigates his suitability to serve on the board and to be the chairperson of that board? I honestly think we need to look into that. Yeah.
Okay, I can start, Chair.
Remember we were talking about
Yes.
Honorable Waters has suggested that we ask the portfolio committee to look at the suitability or otherwise of the current chairperson of this in light of whatever happened here. It's a new proposal.
That's correct.
So I'm asking members to comment on it before we even do anything on our side.
Okay.
Because everybody wants to speak and we start with doing this all this.
Okay, that's fine.
Okay. Let's
No,
start.
yeah. No, Chair.
Once again, a minute and a half.
Yeah, Chair, the Portfolio Committee of Public Enterprise will not have had an opportunity like where we had and exposed to the operations of Mr. Ben Ngubane, Dr. Ben Ngubane. Therefore, I'm going to suggest that it must be our own reflection that must guide his chairpersonship of any board moving forward, having identified how he failed to adhere to the law, and therefore we may not want to refer this matter anywhere else. Maybe when we deal with the recommendations, having in fact understood the role of Ben Ngubane as a chairperson of SABC, we can reflect around those lines rather than referring it anywhere else. We deal with it in the committee and we make a recommendations about him. The public protector's report finds him under SABC, so therefore we may not want to take this into public enterprise. I think if we are to spend more time, it will require us, when we come back, to spend time around him, especially not separating what the public protector has sort of raised around those issues. And I think in the implementation of the public protector's remedial action, it deals with the issues of the role of Dr. Ngubane in detail. And therefore, I think let us maintain and deal with it in-house, rather than taking it to any other person. Because any other person will not have the privilege of what we have.
Time is up.
Yeah, thank you.
Honorable Kosa.
Thank you, Chair. Chair, I was just wondering if we shouldn't have something on, before we could come with that recommendation, whatever recommendation that we are going to be tabled to the House for the committee that oversees ESCOM to look at. I was just wondering if we shouldn't we consider linking this with our own evidence and our own observations, because my main worry is that you're coming with something, but there is nothing in the report that specifically speaks to that. But again, Chair, I'm just looking at 14.8.1, where we've agreed that all potential misleading or contradictory evidence relating to SABC board minutes, commercially sensitive, whatever, and all those other things that we've mentioned there. We've also went further to talk about some kind of recourse for those people that may have misrepresented information to the committee during this inquiry. Now, if there is going to be that process, are we not jumping the gun then if we are now saying the committee that oversees ESCOM should be taking action on him? What happens to that process? And I'm saying maybe we may have to revisit our own observations and factor that specifically in if we feel strongly enough about it.
Can I give some sort of guidance without depriving everybody else? Let me just remind honorable members that on Friday, what we will have is a draft report including draft recommendations as well. That's what it is. It's not a full report. And we will send it out to affected parties for their comments. Shouldn't these things be matters that we deal with after the comments have come in from, not putting it aside, but dealt with, because we've reflected on them in the observations and in the body. And all of them, I would imagine, are going to want to respond and clear their name or respond and clarify, including the lawyers or whoever the case might be. Shouldn't some of these be ones that said, having given you the observations, you've come and said what you want to say, we now feel, and I'm not saying it's the route you're taking, but we now feel this is how we should handle it. Otherwise, we'll be bogged down with all these things before. I'm not saying we shouldn't do it. I'm just trying to give some guidance, because this is not the last bite, by the way. So as you respond, talk to the specific one that that Honourable Waters has raised, Kwankwa, and then followed by Van Dam. You'll be the last one again, Waters. So we'll jump you, and you'll be the last one when you come back, because you introduced it. Kwankwa?
Chairperson, indeed, we agree with Honourable Waters, but I think the proposal that you've just made right now is the correct way of taking this process forward. To say, let's afford them an opportunity to comment on whatever we've said on the report, and then take it further. But I think we must try to separate the two issues. There's one about lying under oath, right, where there are contradictory statements which the legal people are going to help us with. But I think in broad terms what Honourable Waters was talking about, while he's still busy drinking his water, is that he was talking, there's water in front of him. Well, he was talking more about the leadership of Dr. Ngubane, and whether we should still allow him, or it is okay for him to still occupy senior positions in boards of parastatals in light of the evidence that we've reviewed as a committee. And I think insofar as that is concerned, he is correct in saying that a recommendation, even after we've considered their input, we should still recommend, in keeping with what we've done, by the way, with the Portfolio Committee around issues that affect the Portfolio Committee on Communications, we should still recommend the Public Enterprises Committee to do something about the chairperson of the ESCOM board, for example. Right? Siabulel.
Thanks, Chair. I mean, I agree with Honourable Chauke's point that we should just outright recommend that he cannot serve on the ESCOM board, but I'm also cognizant of us making sure that we follow procedure. Now, I'm not sure what the ESCOM Act says about inquiries into the board. I think we should just defer to that, and certainly still recommend that it should be a process taken on by the Public Enterprises Portfolio Committee once we've seen what the ESCOM Act says. Yeah. Thank you, sir.
Chair, thank you. The comments made by Dr. Koza with regards to this matter falling within the matters of 14.5.1 for me holds water. If we pull certain aspects out of the report and want to come up with a specific recommendation, it's going to be a problem. That's not how we have approached the matters. And my view is let's deal with those matters all under 4.5.1. Otherwise, we must then pull everyone out, or every aspect out, and deal with it. I mean, just now we dealt with the bill. And because the bill is something that came to us in a particular way, we've obviously said handle it in the manner in which you have to handle it because it came to our attention. But I want to think that the issues that are coming here as contradictions should be dealt with through 4.1.4. But indeed, if indeed there are other aspects that we may want to resolve on, I think let's do it in the manner in which you've recommended.
Chair, I wanted to say the recommendation that you came up with for me is the correct one. And I'm not saying that what Honourable Waters is coming with cannot be embraced within that. It can. But I think let's have the report with us, the comments, and we have it before us, and then we see who has said what. And then we take it from there. Because we must also be mindful of the fact that we have to follow the process correctly. We have a picture. We have the evidence. We have the observations. We have the recommendations. Let's have a holistic picture, and then we're able to factor it in. That is my take, Chair.
No, Chair, I agree with Honourable Waters on the possibility of Mr. Ngubane's ability to lead ESCOM. But I think we must do it in line with other legislation. You know, Honorable Van Dam is correct in we must look at the ESCOM, I don't know if there's an ESCOM Act or whatever it is that we must look at that. Yeah, I wanted to add another issue, and it's kind of related, no? Can I? No, because also there's the issue of... No, let's finish it. Yeah, okay, no problem. No problem. Thanks, Chair.
Thank you, Chair. Vincent. Thank you, Chair. I am also in support of Mr. Waters. I think we just need to phrase it very carefully because I'm also understanding Dr. Khoza saying we're already looking into some people. Why are we now highlighting a specific person? But this is a person that there is a public protector's finding against, and there was additional contradictions in the evidence, and he is holding a very high office. We need to phrase it very carefully, though. We need to say that we are considering referring this to the public enterprises, and therefore he will then be given the opportunity to respond to that before we make a final finding. So we can't say we're going to do that now, because remember, he asked specifically for us to refer our interim report to himself as well. Thank you, Chair.
Chair, your proposal covered me. I just want to caution us all that let us not act as a super ad hoc committee. When we are sent to do A, we say we are also doing B. Remember, what we are supposed to do when we look at this matter after the process we have outlined is to say, because we were sent to investigate eligibility of the board of the SABC, how has his appointment impacted on what we were directed to investigate? I don't want us to be viewed as people who are witch hunting. We are focusing on the terms of reference so that we don't find ourselves giving each and every committee program to do. We may not be comfortable by evidence led in front of this, but that does not give us powers to also say, because after you have left this area where you made a mess, you landed somewhere, let us look for another process to raise that particular thing, but not cloud the work that we are doing. Thanks, Chair.
Thank you, Chair. Can I just say that I also believe that if we have any recommendation, it should be also grounded on observations that we have captured. Now, in this regard, we have not, to the best of my memory, captured anything, which is something that we should add. And I would like to suggest, before we consider anything else, is we could add observations should capture a sense of unease about the evidence by previous board chairpersons which contradicted evidence presented in the public protector report. If we do that, at least we anchor our sense of unease about that. And the reason being that, Chair, we must go every time look at our mandate. What was our mandate? Our mandate was to look at the board and its suitability, and then evidence was led that it came a long way, and we also called in the previous two board chairpersons. And then we felt we have found contradictions. So I think that could go in. What you do with that in the recommendations, that is where we have to be very cautious. We are not a super committee. We are an ad hoc, and we have dealt with our matters. I don't think we have any other role but to perhaps say the Portfolio Committee on Enterprise should consider the evidence led by the incumbent chair of, and should take appropriate action, so that we don't tell them what to do. They can consider the evidence which contradicted evidence presented by the public protector and should take appropriate action. So that we then don't regard ourselves as a super committee, we just bring it to their attention. So that would be my recommendation.
All right. Before you'll carry on, again, honorable members, in trying to marry everything together, remember we took a conscious decision that ours is going to be a inquisitorial and not acquisitorial. And that is why in trying to marry what you suggested, Honorable Waters, is that on the 28th, whatever the date is when we get it back, depending on the responses we get, not only from Dr. Ngubane, but everybody else that might be, we might be in a stronger position to say, in our inquisitorial section, this is what we observed. Manje, you've come back with that answer, you know this is what we should be doing. That's what I was cautioning against, as opposed to us, I don't want to say jumping the gun, but doing it that way. But let's allow you the last word, because we're going to have to come back to it if we don't agree on Thursday to find a way of marrying the various options. But it's over to you, sir, as the last bite on this matter.
Thank you, Chair, and thank you to everyone for the input. Chair, I agree. We need to, as Honourable Killian said, we need to anchor. If we're going to make a recommendation, we need to anchor it in observations. So, and I do think it's important that I think everyone's talked about it and expressed views that we believe the two previous chairpersons of the board did give misleading information, and they contradicted the Public Protector's report. And I think we actually need to say that in our observations. And that would also give both previous chairpersons opportunity to respond to that when they get the report. So we then could see how they address that, if they do. But I do believe, and I'm not saying we're a super committee, and I don't want us to exceed our mandate either, because it would just undermine everything we've done here. But Parliament, at the end of the day, will either accept or reject our report anyway. So it's not up. We're not the super committee that's dictating to everyone. But I do believe that we would be erring if we did not make the recommendation, simply because Dr. Ngubane was such a bad witness. He really was. It was actually quite embarrassing at times. And the fact that he holds such an important position in another parastatal, which we know is having its own challenges, for want of a better word, that I honestly believe we would be erring if we didn't make that recommendation. Because, a year down the line or something, people might say, well, why didn't you dealt with him? Why didn't you make this recommendation while you were busy with the SABC board? Why didn't you take the opportunity? And it doesn't mean that, Parliament, as I say, must decide on our recommendations anyway. They may reject it. They may not. Thank you.
Sorry, ma'am. Sorry. What we were saying is that we have both versions. As with everything else, we will reflect the 2 or 3 or 4 versions, whatever they are, and when we come back on Thursday, we'll try and we have to go out at one position at the end of the day on Wednesday or Thursday, whenever it's going to be. But Honourable Mokoena wanted to introduce a new one. So that will be 4.8, 1488.
Yes.
Yourself? A new one? No, I did recognize you. I'm just looking at you because as at some point we took a decision, we're not going to call any more witnesses. We're also not going to call any more everybody coming with something new. So is there anybody outside of Mokoena and Mahlangu that wants to be? Because remember, we're talking about stuff that's not on the table. But we can't allow for an endless new entry. Going once? Let me clarify what I'm saying. We are done with the report. We are done with the report. Honourable Mokoena wants to introduce a new Waters introduced a new subject. Mokoena is saying he wants to introduce another one that we don't have to accept, but listen to him. Mahlangu is saying he wants to introduce a new one. We can listen to him. Is there anybody else besides where we're going to? Because remember, everyone that introduces, we have to have a sense from everybody. And I don't want us to be here after lunch if it's not necessary. That's all that I'm saying. Okay, it'll be Mokoena, it will be Mahlangu, and it will be Chauke. And we will deal with each one as you introduce it. We will argue it and take a decision after you've had the last bite. Put it in, and everybody else. It is now 12:30. 1 o'clock, we're done with this matter.
Yes,
Mukwena.
No, Chair, I think in line of the observation of state capture, which I prefer to call SABC capture, I think it's probably a more appropriate terminology to do. And in line of the evidence that we got in terms of the TNA, the attempts to rebrand SABC news channel and so on and so forth, all that evidence, I think we must recommend to the portfolio committee to investigate the possibility of an SABC capture by certain individuals, whoever they are. And that investigation must be performed by the portfolio committee. And just as an addition, I think, yeah, I hope nobody misunderstood me. I didn't say Claude is right on the 90-10 thing. I was saying he's correct in bringing up the subject of content and thing, because I see the media is already misquoting me here. Thanks very much.
You know, then we can adjourn the meeting because you guys have dealt with everything. Can we adjourn? No. You either behave, otherwise we adjourn. Honorable Chauke is not Chauke. Honorable Mukwena's point we're dealing with. The portfolio committee to investigate the potential of SABC influence or undue influence. I don't want to use that term that you're using. Undue influence at SABC. That's the point that he's raising. Anybody wants to talk on that matter? Only on that matter. Kubisi, you'll be number 2. Please remember your number, and you'll be number 3.
Yeah, Chair, I'm aware that Honorable Mukwena is bringing in another etymological meaning, bringing the word capture. The word capture, but we've been speaking about undue influence. My fervent belief was that although he's bringing in capture, but it could be taken to this interference and influence that I've been talking about. And although it's a new concept altogether of a capture, but I think it should go there, to the issue of influence, interference.
But I don't know, Chair, that unless we're not sure of what we have already dealt with and what we have uncovered out of the whole hearing that we have had. And I think that area will be covered in what we are recommending moving forward. You don't have to go and open up another investigation somewhere, state capture, SABC capture, what. Let's deal with what we have dealt with in the meeting here. We're making recommendations, and we are making recommendations to the accounting authority that must be in charge of driving SABC moving forward. We're insisting on that point, Chair. Therefore, there's no need for us to give it to any other person other than the accounting authority that must seize itself with these issues that we have uncovered. So how you want to capture it, Ndate Mukwena and colleagues here, is that in our recommendations, we need to emphasize issues that the board must look at. The board must look at the following. The interim board must look at the following. If you want to spread it, we are doing the very same exercise now as if we did not achieve what we wanted to achieve. What we wanted to achieve so far, Chair, we have able to understand the depth of the problem at SABC. Therefore, the accounting authority takes responsibility of the following issues. So I think that's a position that we must take, Chair. If we are going to raise another hype of a state capture, SABC capture and all of that, it's just going to be, it will definitely reflect as if we have not finished to do our work here. I thought that what we have identified will give direction, in fact, to the incoming leadership to look at the following issues. And that's the point. It can be put within the leadership that must be established of the SABC that can look into the following issues. Due influence from others. We have dealt with the political one. We have dealt with the business people who are involved in the process. We have captured SABC, your TNA and all of that. We have dealt with that. So let it be the accounting authority that must deal with such matters.
All right. Loliwe. I thought, you know, it's fine. Let's allow Loliwe, and then I'll try and summarize.
Okay.
Yeah. No, they're trying to capture this committee now, all these people. I thought we were done. Loliwe, what's your point?
Chair, I think Honorable Mkwena was unfortunately riding a bicycle in a storm. Because the point he wanted to drive home was to clarify himself on the cloudy thing. Secondly, we can't, on each and every recommendation we have made, try and come up with a committee that is to take that point further. To me, this is not different from the undue influence we have already identified. So there's no need to duplicate the work where we have already made a recommendation. I think the world helped you, my brother, when you clarified yourself. So please drop this one. Thanks.
Hi, Chairperson. I think Sanumshaya Lokpan, Honorable Mukwana on this matter. I want to cracks. You are right in saying it has been covered. I think we've covered it more specifically when we spoke about the examples around the TNA breakfast and that it should be looked into and so on. I think state capture or capture as a term is a nice political term, but I think we've covered it in detail in the context of the report, so we can't accommodate it, in my view, in this respect. Thank you.
I like Mkwena because he doesn't argue too much, but I think we have captured, we have covered it. We have covered it. Masangu, you wanted to introduce another concept. Please slowly as introduce it so that we can argue.
Chair, it's two matters that are almost very simple to look at. And I think it's just an example that we should make as a committee. The people that descended to the portfolio, assumably at the course of the SABC, and left, I assume they were on holiday, but they visited the committee. My view is that their total cost should be to their pockets. That's the first one. You know those people, 17 of them? Okay.
There was
I'm done.
No, I'm just going to try and summarize so people can talk to it. There was a delegation that came, I think it was the 7th of December. Staff members of the SABC. The suggestion is that we must make a recommendation that costs related to their trip down to Cape Town must be for their own pocket. That's what is being suggested. The SABC, when the SABC board came down, they were supported by 16 or 17 other officials. Proposal that is being made is that we must recommend that those expenses related to their downward trip must be for their pocket. Because I would assume that the SABC paid for the airfare and the accommodation and all that type of thing. That's the simple recommendation you're making. No, let me not even ask for comments. Let me put it to you differently. Anybody opposed to that one, raise your hand. You opposed to it? Yes, sir.
Just in the case where they were instructed to be here, then obviously it will be a different situation. So you need to just add that caveat, unless they were instructed to be here. Because if you're a staff member and you're instructed to be here, there's nothing you can do about that. So I think I am fully supportive of the sentiment. How one determines that is a different challenge, you see.
I would also add that there must be disciplinary action against anyone who publicly went against the instruction of Parliament. Talking about the GCEO and everybody else, because we still have board members, the GCEO in particular, who went and publicly said that they are not going to adhere to the parliamentary call. And we must deal with those people and we must set a standard going forward.
So what are we saying? We're saying that, what are you saying to the point that's made by Honorable Swartz? Because he's saying if they came back and said it was a company instruction, you recall when they were there, I had said, and this is what we say in Scopa all along, please ensure that you don't do this thing because it's fruitless and wasteful expenditure. Now, many delegations come to Parliament like that, and all we can do is to say, don't. I don't know how you'll implement what you're saying, Honorable Mahlangu, if they turned around and said, well, this was a board instruction. Because then it must be the board that, I see somebody raising his hand there, I'm not going to allow you to speak there at the back. I'm just saying this thing that you're saying, the sentiment is clear. How do you implement it?
If it's the board, remember you didn't have a board, you would have the CEOs and whoever else. But it has to be from a personal pocket. All I'm saying is state resources should not be used for that trip. So if they show me as the head of whatever, then I must take the brunt. I must fit the bill. That's all we are saying. If JL said, let's go to Cape Town on that holiday, JL must take the bill, must take the tab, Chair.
Can we ask the incoming or the interim board to investigate it and to recover funds? Because they will know who the delegation was, instead of us having a big debate about it. Is that fine? Yes. The second point you want to raise, sir.
Chair, the second point is something that, well, it came to our attention. We don't know whether there's policy or not. Your non-executives, we were told they have got offices and staff, and others are afforded vehicles. If there's a policy, I think the incoming board should review that policy. If there is no policy, that matter should be dealt with because it is almost an irregular action, and some of that information should obviously be sent to SARS because it is a benefit. If I get a vehicle, I'm a non-executive, it's a benefit, and SARS must get some revenue from me. So all those smaller things that we may actually ignore, they have become a culture, which is something that we should try and reverse. I think either the board or the administration should actually deal with those issues.
We're trying to capture it here. So your recommendation is that somebody must look at the perks received by non-executive members of the board. That's what you're saying in essence. And it must be aligned to Companies Act or whatever act, and there should be no undue. That's what you're saying in essence. All right. Well, the new board can do that, isn't it? And align it. All right. We'll try and capture that one. And of course, on Thursday, you'll have a bite. Can we move on that one? Okay, introduce you on Honorable Chauke.
No, mine, Chair, it's a simple one, obvious. Since we started with the work of the ad hoc committee, Chair, we have met current and previous leadership of SABC. And I want to propose that before the final adoption of our report, before it's submitted to Parliament, we should organize a oversight as this ad hoc committee to SABC to meet with the current leadership at SABC, just to have a feel of a situation that that we have dealt with, directly interacting with the. It will be very important, that oversight, Chair, because it will help us to have an understanding, even ourselves, in our final recommendations as we'll put them forward. So I'm proposing that we have a session that interacts at that level, just the high-level leadership of the SABC currently, not only the CEO, your CEO, your what you call your COO and others, but even your general leadership that is core. People who have in fact kept SABC moving forward even out of this most difficult time. But just to interact, have a feel, and that feel will definitely have to be reflected in our report too, of what we have picked up under that oversight. It's very important, Chair, because throughout we are dealing with SABC. We have not yet found time just to go to SABC itself and just have an understanding of what's happening. I thought that it will be important. In fact, it will enhance the work that we have done so far with that particular oversight that we must do there. Thank you.
That can't be a recommendation in our report. That is something that you're requesting that we must follow up. So I'm not even going to open it up because that's not a recommendation. I was asking for new recommendations. there's the point that is being made by Honorable Chauke that there's some sort of oversight, and that, of course, is dependent on the program on Parliament and whether they're going to allow oversight or not. But that's not a recommendation in the report. Do we agree on that one? All right. I don't know what's the policy, but we will ask the powers that be, the frolics of this world or whoever of this world. That's fine. Honourable members, then, that deals with our 38-page report. Let me just reiterate so that we understand. Going forward, we are going to try and capture everything that has been said today and on Friday, because today is Monday, Tuesday. Can we get it this afternoon so that we look at it on Wednesday? Okay, I'm fighting with the boss here. As I understand it, there's a report that will come out that will say on point 1, Vincent said this and John said that, where we haven't reached consensus. And that report has to come back here for us to discuss, to get one view on it. So we'll fight about it, get one view, and therefore a third report will have to be presented with the one view on it. Correct? Yes. So now I was asking you, can't we prepare a report sometime today that will come out with the 5 versions of the last matter, for instance? Or are you saying, because Friday we want to adopt. If you're going to adopt on Friday, it means by Thursday you must get a report that we're going to adopt, isn't it? That's ideal. By Thursday they want to get a report they want to adopt. When are we? Okay, what Cindy is suggesting is fine. What is being suggested is that between now and Wednesday, we will try and fix up the report, and on Wednesday you'll get a report with 2 versions on it. Let's assume there's one point that has got 2 points on it on Thursday afternoon. When we come on Friday, instead of having another bite and another bite, we're going to have one more bite after this. So when we come on Friday, we're going to debate and finalize what we are saying on whatever point it is. I thought we would have 2 bites so that one is clean, but I think this one is probably the better one, which means that today, by Wednesday, you will get a report that will say on point 1, this is what Swart said and this is what Smith said. When we come back on Friday, we're going to argue the Smith and Swart point, either delete the Swart one or delete the Smith's one or merge the 2 ones. So it means Friday we're going to have the real hard. Is that acceptable to members? We can do it on Thursday.
On Thursday, Chair.
Oh, we can do that on Thursday.
That's what I was going to propose.
And fix it up on Thursday. And then Friday we just rubber stamp it.
Correct.
All right.
And where possible to try and marry events.
That's what we are saying, yeah.
And then, Chair, the legal input. The lawyers also need to look at it, this draft. So even if they look at it, because they also need time to put in their inputs, besides what we've asked them to do, but just to look at the report in general, whether it's possible to send them a draft as well as soon as possible.
All right. All right, you'll get a report sometime on Wednesday. Tomorrow, yeah. On Thursday, we're going to sit and fight and argue and agree and disagree and resolve on all those matters. I'm saying if we agree on the principle, we'll go back, and then on Friday, we'll come back and adopt it after we've had our fight. We'll be just adopting whatever the position is. So the question is now relevant. Before the relevance of the question, how much time do you want? Can we deal with it at 9 so that by 2 we're done? If it's not that hard, if we're not done by 2, we'll have until 6. I don't know how tough the negotiations and the fighting is going to be. Friday, I don't imagine it taking longer than an hour because it'll be adoption. So can we agree that we again start at 10 And if we finish at 1, we finish at 1. If we need more time, we need more time. That's on Thursday. Is that okay? Yes, Chair. All right. So that is it. We're going to go back and do some homework on what we've done. We are not accepting any more input, except, Van Dam, you're going to give us what you asked for today. You know, this relates to clause 1 of the Constitution and so on. So can we agree that by 2:30, and those are the only inputs we're receiving, those that specify the acts, we are going to go and try and clean up this report and get it to you sometime during the course of the term on Wednesday so that you go back and look at it. And on Thursday, we're going to have our committee fight about it, and on Friday, we're going to adopt our report. Is that all right? Somebody wants clarity, let's take yours. Do you want clarity also, Chauke? No, let's take Killian.
Chairperson, you've earlier said that our report that will go out to the people for comment will obviously be the sections up to section and including section 13 with our observations. But that obviously we will have to, we've gone through the recommendations, but we will have to wait for comment from the individuals. So we're not going to distribute the recommendations part because we will have to demonstrate that we are awaiting feedback from those who may have been mentioned in the report. Is that correct?
No, I had said that argument, or not that argument, that point we need to discuss on Friday. The other point, now that you're raising it, we'll have to decide, honourable members. The other point that I was raising, and maybe you must tell us, you'd recall, Honourable Kwankwa, at some point we had taken a decision that we don't want to put names in the report. And this committee said, no, put the names in the report. Now, it's going to end up with about 40 names. I'm using that as an example. And I'm looking at the legal team there. Does that mean that we must write to 40 people because we've named them? Whereas if we had put, and I'm asking you for some advice between tomorrow, if we had put the office and we had a glossary that said, when you talk about ex-chair 1, you're talking about Vincent, ex-chair 2, you're talking about John, as opposed to putting Vincent and John in the body. I'm not saying it's right or wrong. I'm just saying somebody must tell us, because that's going to inform who do we distribute this report to. And at that point, we'll then decide this matter of yours, of that whole report that we are sending out for comment. I mean, we don't want people to comment on our recommendations. Those are our recommendations, for instance. But I'm saying that debate we'll have. Do you want to say something on this matter? Yeah.
Chair, the issue is, if you mentioned an office, it's the same. It's the same principle applies, or the name, but it's only we gave undertakings to send it to the SABC and 1 or 2 people that asked. It was Mr. Ngubani, it was 1 or 2 people, and the minister. I don't think it's necessary to send it to every person, Sunri. So that's my view, Chair.
No, we don't want a response, ma'am. We're saying to you, I was saying these 2 points that were raised now, we don't need clarity today. When we do that report on Thursday, can you give us some homework on those ones and we decide exactly who we distribute to and so on? Is that okay, Honourable Killian? And also the extent of the report and so on. Honourable Chauke.
Yeah, no, I think let's come back again, Chair, to the position that the report that will be an interim report will not be a secret document, so that we deal with the issue of what we dealt with last time, that it was a leak and what. It's a public process, and I think that report, as much as we'll send it to the relevant people that are affected, that report will be available to the public without saying that let the public comment, but it will be available to the public, so that the notion that this report get leaked and all of that, we are dealing with an open process, and this open process therefore means that whatever the outcome or the final report that we are going to be in position of next week, which is the interim, will be a public document again. I think that principle needs to be maintained.
Right. So it's wrapped up. It's 5-1. We're done. We will get a report out to you sometime on Wednesday, and we will notify you of the venue of where we're going to sit on Thursday. We've also agreed, Waters, that it's at 10 o'clock. Thursday. We're not meeting tomorrow. Wednesday is our day to do some cleanup. Thursday we'll meet at 10, And worst case scenario, we'll finish at 6 or we'll finish at midnight because we've got to complete that thing because Friday we're going to adopt it.
Oh, okay. So that's the equation.
No, I'm saying if we behave, we'll finish early. If we don't behave, we'll go until midnight because Friday we have to adopt it. That's fine. All right, so that's the way going forward, honorable members. And then, of course, the legal team will come back with an answer in terms of how and where do we distribute it, taking into account what Honorable Waters has said. We'll also discuss how do we distribute it, when do we distribute it. And this meeting is then adjourned until 10 o'clock on Thursday. Thank you very much.